Hello, hello, hello. Am I live? Hello, hello, hello. Can someone let me know if they can hear me? We've got a new motion land in the... Can someone just... Yeah, okay, you can hear me. Great. I'm not talking to myself. That's good. We should, hopefully... I can't see what's on the screen at the moment, so I don't know why that is, but let's just see if that's because I'm looking at the wrong thing. Hang on a sec. There, that's made a difference. Okay, so I'm going to be reading, so I'm not going to be watching the chat, which may mean I'm not sure if I'm going to have a moderator in here, but I'll try and look occasionally to check that no one is spamming the chat. But other than that, I'm going to be reading because we have a new motion in the Vegas case of Floyd Wallace. And the police officers are making an appearance. So, here we have it. I better, you know what YouTube's like with phone numbers. I better not go over that. And you're probably hearing my squeaky chair, but never mind. So, and let me just check the chat just one last time before I start reading. I've lost my mouse there for a second. Okay. Yeah, on the screen was the statistics. I think I had the wrong window ready. But hopefully you can hear me. And if you can't, well, let's go. So, defendants, Officer Torres, Officer Shoemaker, Officer McCormick's motion to dismiss. And I did notice that they're represented by the same law firm as is representing LVMPD. Defendants, Christopher Torres, Jason Shoemaker, and Corey McCormick, by and through their attorney of record, Marquis Urbach, hereby file their motion to dismiss. This motion is made and based upon the memorandum and points of authorities, the pleadings and papers on file herein, and any oral argument allowed at the time of hearing. Memorandum and points of authorities. 1. Introduction. Defendants Torres, Schumacher and McCormick are Las Vegas Metropolitan Police Department officers, collectively defendant officers. On May 10, 2023, plaintiff Floyd Wallace covered his face with a mask, travelled to an LVMPD substation and began filming inside a restricted area. Wallace's intent was to draw attention to himself and provoke a police encounter. When the defendant officers detained Wallace to investigate his suspicious behaviour, Wallace initially refused to identify himself and argued the officers were violating his First Amendment rights. The defendant officers arrested Wallace and took him to jail. The district attorney did not pursue the charges. On May 24, 2023, Wallace filed his complaint, ECF number 1-1. Initially, Wallace only served defendants Las Vegas Metropolitan Police Department. LVMPD filed its motion to dismiss on July 17. Don't know why it says 2017 there, because obviously that was 2023. On August 14, 2023, Wallace served the defendant officers. The defendant officers now file their motion to dismiss. Although many of the officers' arguments mirror those raised in LVMPD's motion to dismiss, the officers also raise their qualified immunity defence as set forth below. All Wallace's claims must be dismissed. Background: Wallace's facts. The complaint. According to Wallace's complaint, on May 10, 2023, he went to LVMPD's Spring Valley Command Substation to record police officers, ECF number 1-1 at 17. Wallace covered his face with a mask and positioned himself at a gate with signs clearly prohibiting public access. Wallace then began filming arriving police vehicles. A plainclothes officer approached Wallace and asked plaintiff what he was doing. Wallace ignored the officer and returned to the public sidewalk. I'm not going to worry about the IDs. Once on the sidewalk, several officers conducted Wallace. Once on the sidewalk, several officers contacted Wallace. An officer approached Wallace with a drawn gun, directed Wallace to the front of a police car and handcuffed him. Wallace was told he was being detained on reasonable suspicion because video surveillance showed him trying to enter a gate not open to the public. As the officers frisked Wallace for weapons, he asserted his right not to have his wallet searched and asked for supervisor. Wallace refused to provide his identity. When the officers threatened Wallace with arrest, Wallace finally provided his name and birthday under threat of arrest. Wallace claims the officers racially profiled him, accused him of being a terrorist and a possible auto thief. Eventually, Wallace was arrested for attempted trespassing. Wallace was transported to jail and released with a citation. Wallace's videos. Wallace videotaped the subject encounter on 2 devices. Although not referenced, thanks, I'm a legend, nasty look, Daniel. I just looked at chat. I shouldn't do that because it interrupts me. Wallace videotaped the subject encounter on two devices. Although not referenced in his complaint, Wallace has requested the court take judicial notice of his videos in other filings and represented the videos are true and correct recordings of his arrest. Wallace's video shows him recording an LVMPD officer's private vehicle driving into a restricted area. The officer exits his vehicle and tells Wallace the area is restricted. Wallace never responds, walks right up to the gate and lingers for a few moments, and then turns and runs back to the sidewalk. At the sidewalk, Wallace stops and waits to see if the officer is following him. When he sees other officers walking and driving towards him, he says to himself, "Okay, they are coming, they're coming." He then turns and begins to walk away from the approaching officers despite their orders to stop, police. And there's some video exhibits. One officer approaches Wallace on foot with his firearm drawn at the low ready position, brackets, i.e. not pointed at Wallace, close brackets. Wallace says, "You got a gun pointed at me." The officer orders Wallace to the front of the car, and Wallace ignores the command and says he will only comply if the firearm is put away. Wallace is eventually placed in front of the police car where he refuses the officer's request to identify himself for over 3 minutes, claiming federal law trumps state law. Wallace refuses to provide any other identifiers and continues to obstruct. He tells the officers his suspicious activity is his way of expressing his First Amendment rights and that everyone has their own way of doing it. During the stop, the officers discover that Wallace has a warrant from a different state. Wallace's background. Wallace is a First Amendment auditor. First Amendment audits are a social movement that involve photographing or filming from a public space to test constitutional rights, particularly the right to photograph and video record in a public space. If the encounter results in an actual or perceived violation of the auditor's First Amendment rights, the video is posted on YouTube and the auditors file suits. Auditors are purposefully confrontational and provocative. Since filing this lawsuit, Wallace admits, "I have been illegally jailed 3 times in the last 30 days. Prior to this lawsuit, Wallace filed an almost identical lawsuit in Texas. In that case, Wallace, in 2021, went to Tomball, Texas Police Department and began creeping around a police tower and filming the parking lot with his phone and body-worn camera. When officers approached him, he bolted. When the officers asked to investigate, Wallace refused to provide identification and protested that the officers were violating his rights. Eventually, Wallace, in hopes of avoiding arrest, Wallace verbally provided his name, birthday and address. The officers arrested Wallace for evading a police officer and failing to identify himself. All of the charges except the evading charges were dropped. There was not sufficient probable cause to support the charge. Wallace sued the officers and the police department alleging false arrest, unreasonable search, First Amendment retaliation, malicious prosecution and a Monell claim. The district court denied the officers' qualified immunity request as premature. The Fifth Circuit reversed, finding the officers had reasonable suspicion to lawfully detain Wallace, had the right to search him after he refused to identify himself, and that the officers were entitled to qualified immunity on the malicious prosecution claim. Wallace's claims for relief. Wallace's complaint alleges the following claims for relief. First cause of action, 42 U.S.C. 1983, claims for false arrest and excessive force against defendants Torres, Shoemaker and McCormick. Second cause of action, 42 U.S.C. 1983, and equivalent rights under the Nevada State Constitution for equal protection violations against defendants Torres, Shoemaker and McCormick. Third cause of action, 42 U.S.C. 1983, and equivalent rights under the Nevada State Constitution for free speech retaliation. Fourth cause of action, Monell and supervisory liability against LVMPD. Fifth cause of action, for intentionally discriminating against Wallace because of his race and political affiliation and viewpoints against Torres, Shoemaker and McCormick. Sixth court of action, state law assault against all defendants. Seventh court of, I looked at chat then for a sec. I looked at your chat for a second and got lost, sorry. Seventh court of action, state law battery against all defendants. Eighth cause of action, state law false arrest and imprisonment against all defendants. Ninth cause of action, state law invasion of privacy claim against all defendants. 10th cause of action, state law negligence claim against all defendants. On July 17, 2023, they got the date right this time, LVMPD filed its motion to dismiss. That motion is fully briefed and pending. Thus, this motion only involves the claims against the individual officers. Before I go on to 3, you may remember that I did a reading of Mark Stout's amicus curiae brief in the Reyes case. And Mark got quite annoyed with me. I got a fairly nasty letter threatening me. I don't know why, but perhaps because I've made fun of the attorneys here making a date mistake, I'll get a threatening letter from these attorneys. Who knows? Anyway, on to 3, the legal standard. Motion to dismiss standards. And I just managed to somehow lose my window of the live streaming. God knows where that's gone. Oh well, I won't see you at all at the moment, so never mind. A, motion to dismiss standards. Under Federal Rule of Civil Procedure 12b-6, a complaint may be dismissed for failure to state a claim upon which relief may be granted. Dismissal for failure to state a claim is a question of law. There's a reference. And is appropriate when a plaintiff can prove no set of facts in support of his claim which would entitle him to relief. Further references. The Supreme Court has addressed the minimum standards a complaint must meet to withstand a motion to dismiss under FRCP 12b-6 when measured against the pleading requirements set by FRCP 8a2. While a complaint attacked by a Rule 12b-6 motion to dismiss does not need detailed factual allegations. A plaintiff is obligated to provide the grounds of his entitlement to relief under Rule 8A2. It requires more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. Further references. The court extended the pleading requirements articulated in Twombly, an antitrust case to all cases. As a result, factual allegations must be enough to raise a right to relief above the speculative level on the assumption that all the allegations in the complaint are true, even if doubtful in fact. To satisfy FRCP 8A2, a plaintiff must plead enough facts to state a claim to relief that is plausible on its face. Twombly, a claim has facial plausibility when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Another reference. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. While a court must accept all allegations as true, that tenet is inapplicable to legal conclusions. Their threadbare recitals of the elements of a cause of action, supported by mere conclusory statements, do not suffice. Ultimately, Rule 8 does not unlock the doors of discovery for a plaintiff armed with nothing more than mere conclusions. Dismissal is proper where there is either a lack of cognizable legal theory, or the absence of sufficient facts alleged under a cognizable legal theory. I could pronounce that anyway, couldn't I? Because I'd get away with it, because I could say that's the English pronunciation, but there you go. As a general rule, a district court may not consider any material beyond the pleadings in ruling on a 12B motion. Another reference. An exception exists if the evidence authenticity is not contested and the plaintiff's complaint necessarily relies on them. Here, Wallace has relied upon his videos in other pleadings and verified their authenticity. B. Qualified immunity. Section 1983 is not itself a source of substantive rights, but merely the procedural vehicle by which to vindicate federal rights elsewhere confirmed. Reference. To make out a prima facie case against Section 1983, a plaintiff must show that a defendant, 1, acted under colour of the law, and 2, deprived the plaintiff of a constitutional right. Another reference. The detectives do not dispute that they acted under colour of law. Therefore, the task of this court is to determine whether the detectives violated the Constitution. In addition, the detectives have raised the affirmative defence of qualified immunity. A defendant in a Section 1983 action is entitled to qualified immunity from damages for civil liability if his conduct did not violate clearly established statutory or constitutional rights of which a reasonable person would have known. Another reference. The Supreme Court has often stressed the importance of deciding qualified immunity at the earliest possible stage in litigation in order to preserve the doctrine's status as a true immunity from suit rather than a mere defence to liability. Another reference. In determining whether an officer is entitled to qualified immunity, a court considers 1. Whether there has been a violation of a constitutional right, and 2. Whether that right was clearly established at the time of the officer's alleged misconduct. Another reference. Consequently, at summary judgment, a court can only deny an officer qualified immunity in a Section 1983 action if 1. The facts alleged, taken in the light most favourable to the party asserting injury, show that the officer's conduct violated a constitutional right, and 2. The right at issue was clearly established at the time of the incident, such that a reasonable officer would have understood his conduct to be unlawful in that situation. The reference. 4. Legal argument. A. Wallace's Fourth Amendment and state law false arrest claims fail as a matter of law, 1st and 8th COA. Wallace alleges the defendant officers detained him without reasonable suspicion and arrested him without probable cause. Reasonable suspicion and false arrest law. Reasonable suspicion to detain. A Terry stop, delete laws, is a brief, minimally intrusive investigatory detention. Terry v. Ohio. Although a Terry stop is a seizure under the Fourth Amendment, it is nevertheless lawful provided that the police officers have reasonable suspicion that criminal activity may be afoot. Reasonable suspicion exists where, in light of the totality of the circumstances, the officer had a particularised and objective basis for suspecting the particular person stopped of criminal activity. Other references. During a Terry stop, a law enforcement officer may ask the detainee a moderate number of questions to determine his identity. And to try to obtain information confirming or dispelling the officer's suspicions, without Mirandizing the detainee. Another reference. Reasonable suspicion existed to detain and probable cause existed to arrest Wallace when he was filming outside a Texas police station and avoiding the police. So they've used Wallace's own case there as a reference. Probable cause to arrest. A claim for false arrest is cognizable pursuant to Section 1983 as a violation of the Fourth Amendment when the arrest was without probable cause or other justification. Another reference. To determine whether an officer has probable cause at the time of an arrest, a court considers whether at that moment the facts and circumstances within the officer's knowledge were sufficient to warrant a prudent man in believing that the petitioner had committed or was committing an offence. Further references. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity, and is not a high bar. Another reference. In Nevada, probable cause can be based on slight evidence. Another reference. Finding probable cause existed even though witness identification was in direct conflict with that of another witness. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officers had probable cause to arrest for any criminal offence, regardless of their stated reason for the arrest. Another reference. When the underlying facts claimed to support probable cause are not in dispute, whether those facts can constitute probable cause is an issue of law. Another reference. The Constitution does not guarantee that only the guilty will be arrested. Another reference. The eventual disposition of the charges is immaterial to a court's probable cause determination, as a conviction requires a higher burden of proof than is required to show probable cause. Further references. The probable cause analysis is the same whether under federal law or Nevada state law. Another reference. 2. The defendant officers lawfully detained and arrested Wallace. First, the defendant officers had reasonable suspicion to detain Wallace to investigate his suspicious behaviour. Wallace admits he was wearing a mask, acting suspiciously by following police officers' vehicles, entering an area prohibited to the public, filming inside the prohibited area, and initially refusing to explain his actions to the officers. Any reasonable officer would be concerned regarding Wallace's behaviour and at a minimum investigate it. And they refer to Wallace again. In Dave v. Laird, the Southern District of Texas examined a similar case where a plaintiff was filming a public breezeway behind a police building and a dead-end alley where police officers parked their police vehicles. I've no idea what a breezeway is, so if you type that in chat, I may see that later. When officers confronted the plaintiff, he, like Wallace, responded in a hostile manner. The district court dismissed plaintiff's false arrest claim, concluding that reasonable suspicion existed to detain because plaintiff's filming where police officers parked their vehicles would likely cause suspicion and a reasonable person filming in this area would know that their actions might cause legitimate worry or even fear on the part of police officers who depend on the security of their building and integrity of their vehicles for their safety. And here we see Turner v. Driver being used in a defence argument as opposed to a plaintiff's argument. So Turner v. Driver doesn't mean everything that the auditors like it to be seen as to be shown. Let's see what it says. Reasonable to detain individual filming police station from a public sidewalk, as police can take into account the location of the suspicious conduct and the degree of the potential danger being investigated. And that's straight from Turner v. Driver, the Patusai. In short, the defendant officers clearly had reasonable suspicion to detain and investigate Wallace's behaviour. At a minimum, there is no clearly established law prohibiting the officer's detention, and the defendant officers are entitled to qualified immunity on this claim. Second, the defendant officers had probable cause to arrest Wallace. The officers cited Wallace for attempted trespass. And this is Nevada Statute 207.200(1) makes it a misdemeanor for any person under circumstances not amounting to a burglary to go upon the land or into any building of another with intent to vex or annoy the owner or occupant thereof, or to commit any lawful act. It is undisputed that Wallace approached a closed-off area that was prohibited to the public, began filming officers entering the area, and then fled when confronted. A reasonable officer could easily conclude that probable cause existed that Wallace went onto the property intending to commit a lawful act. I suspect that should be unlawful act. In addition, as stated above, probable cause can exist for a crime not charged. Reference. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officers have probable cause to arrest for any criminal offence, regardless of their stated reason for the arrest. Under Nevada Revised Statute 197.190, it is obstruction under Nevada law to impede and or prolong an investigation. There's a reference. Nevada district courts have held that an individual is obstructing when the individual is given several opportunities to comply with defendant's orders but fails to do so. Another reference. Wallace admits, and his video establishes, that he impeded the officer's investigation by failing to identify himself for over 3 minutes after being asked to do so. Another reference. In brackets, principles of Terry permit a state to require a suspect to disclose his name during a Terry stop. Therefore, at a minimum, probable cause also existed to arrest Wallace for obstruction. At a minimum, there is no clearly established law establishing a lack of probable cause under similar circumstances. B. And before I read B, I must get my window, and I've no idea where it's gone. I can click on it and it doesn't come up. I'm really struggling without being able to see you all. Oh, there it is. Okay. One sec. Well, it's just not must be on another screen that I haven't got open. I must have shifted it onto another monitor. Where's the control for that monitor? I do apologise. I will come back to reading in a second, but I want to make sure that I'm not talking to myself. So chat amongst yourself while I try and locate this remote control. Testing, testing, 1, 2, 3, 4. Testing, testing, 1, 2, 3, 4. Right. I've no idea why that went down. I did spot it. Did we get to B? I think you got to B. If I didn't get to B, then yeah, I think I got to B. That's when I stood up to open that screen. I shouldn't have done that. My apologies for the brief suspension of my audio. At least I had the scroll going so you could read it. Yeah, B. That's where I am. Okay, B. Wallace has failed to state a claim upon which relief can be granted for unreasonable search and seizure of property. First cause of action. Wallace alleges the officers unreasonably searched and seized his property. The complaint alleges Wallace was searched and transported to Clark County Jail. Under Terry, an officer may pat down a detained person who they reasonably believe may be armed and dangerous. This brief search is to allow officers to conduct investigations without fear of violence. Another reference. Further, when a suspect is arrested, a police officer may conduct a warrantless search incident to an arrest of both the arrested person and the area within his control. Here, Wallace was patted down when he was detained and briefly searched pursuant to his lawful arrest. Someone has just sent me a picture of a breezeway, for which I'm very grateful. C. Wallace has failed to state a claim upon which relief can be granted for excessive force claim. First cause of action. Wallace's first cause of action also alleges excessive force. The only force referenced by the complaint, beyond the lawful search of Wallace's person, is that an officer drew his gun while approaching Wallace. Courts approach excessive force claims in 3 stages. Another reference. First, the court assesses the severity of the intrusion on the individual's Fourth Amendment rights by evaluating the type and amount of force inflicted. Then the court evaluates the government interests by assessing the severity of the crime, whether the suspect posed an immediate threat to the officer or public safety, and whether the suspect was resisting or attempting to escape. Another reference. Third, the court balances the gravity of the intrusion on the individual against the government's needs for that intrusion. Another reference. According to the Ninth Circuit, the drawing of a weapon becomes unreasonable when the police officer terrorises a civilian by brandishing a cocked gun in front of that civilian's face while investigating a minor crime against a civilian. Another reference. Brackets, pointing guns at persons who are compliant and present no danger is unreasonable. Here, Wallace alleges an officer approached him with a gun drawn. Wallace's video confirms that an officer approached him with his firearm at the low ready position, i.e. not pointed at Wallace. By simply approaching Wallace with his gun drawn in the low ready, the officer did not use excessive force. Further, Wallace's video confirms that the officers did not terrorise him. Also, Wallace was initially resistant and uncooperative. Once Wallace became cooperative, the weapon was immediately holstered. As the officer explained to Wallace on the video, his gun was drawn due to Wallace's suspicious behaviour and the fact he was ignoring the officer's initial commands. At a minimum, the officer is entitled to qualified immunity, as no clearly established law prohibits the drawing of a firearm in similar circumstances. D. Wallace's 14th Amendment equal protection claim must be dismissed, and this is the second cause of action. Wallace alleges the officers violated his 14th Amendment equal protection rights because they arrested him due to the colour of his skin, his position as a member of the press, and due to his political affiliation. I mean, two of those three are absolutely stupid, because how the hell would they know? To state a Section 1983 claim for violation of the Equal Protection Clause of the 14th Amendment, a plaintiff must allege that the violation was committed with an intent or purpose to discriminate based upon plaintiff's membership in a protected class. Another reference. To prevail, the plaintiff must show that enforcement had a discriminatory effect and the police were motivated for a discriminatory purpose. Another reference. Where the challenged governmental policy is facially neutral, proof of its disproportionate impact on an identifiable group can satisfy with intent requirement only if it intends to show that some invidious or discriminatory purpose underlies the policy. If the action does not involve a suspect classification, a plaintiff may establish an equal protection claim showing that similarly situated individuals were intentionally treated differently without a rational relationship to a legitimate state purpose. Another reference. To state an equal protection claim under this theory, a plaintiff must allege that 1. The plaintiff is a member of an identifiable class, 2. The plaintiff was intentionally treated differently from others similarly situated, and 3. There is no rational basis for the difference in treatment. Here Wallace alleges officers intentionally discriminated against him based on the colour of his skin, his position as a member of the press, and due to his political affiliation and viewpoints. First, Wallace's complaint admits he never told the officers he was a member of the press or about his political affiliations. Thus, the officers could not have discriminated against him as a member of the press or due to his political views, as he never made these facts known. Another reference. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. Further, the press is not a protected class. Second, Wallace's profiling claim cannot meet the final two prongs established in the Willowbrook case. The complaint does not allege Wallace was intentionally treated differently from others that are similarly situated as him, and that there was no rational basis for the difference in treatment. Specifically, Wallace has failed to allege facts suggesting that LVMPD does not detain and arrest non-African American individuals who put on masks, travel to police substations and film police vehicles, and then obstruct investigation. This claim fails as a matter of law. E. Wallace's First Amendment claim must be dismissed. Third cause of action. Wallace claims the officers violated his First Amendment rights by retaliating against him for his speech, including his verbal protests and criticisms of the defendant's actions in investigating, detaining and arresting plaintiff without any basis. Because Wallace admits he never verbally protested or criticised the officers, his claim is really that they arrested him for filming police activity. The Ninth Circuit has held there is a First Amendment right to film the police. Recognise that reference, Fordyce v. Seattle. Another reference. There is a right to record law enforcement officers engaged in the exercise of their official duties in public places. The right to film may be subject to reasonable time, place and manner restrictions. Giltby Cunniff. The Ninth Circuit has held that reasonable content-neutral time, place or manner restrictions, on the other hand, are subject to an intermediate level of scrutiny. I hope Mark Stout's watching this, because this is the element that he thought he was bringing to the New York case. Restrictions in a non-public forum must only be reasonable in light of the purpose served by the forum and viewpoint neutral. Finally, to prevail on a First Amendment retaliation claim in an arrest context, a plaintiff also must plead and prove the absence of probable cause. Neves v. Violet, another famous one, holding that want of probable cause to support the underlying criminal charge must be alleged and proven for a First Amendment retaliation violation be actionable. Here Wallace was not arrested for filming, but rather for attempted trespass. As set forth above, probable cause existed for the arrest, rendering this claim untenable under Neves and Hartman. Assuming Wallace's arrest was a pretextual arrest to punish him for filming, the claim would still fail. Wallace admits he was attempting to film inside a non-public, gate-guarded area that was off-limits to the public. It is reasonable for security reasons to restrict individuals from filming officers leaving and entering police stations. Thus, Wallace has not pled facts sufficient to state a claim against the defendant officers for a First Amendment violation. F. Wallace's 42 U.S.C. 1981 claim must be dismissed. Fifth course of action. Wallace's fifth cause of action alleges the officers discriminated against him because of his race and political affiliations. 42 U.S.C. Section 1981 prohibits discrimination in the making and enforcement of contracts by reason of race, national origin, or ancestry. The Ninth Circuit recently issued an opinion indicating that while Section 1981 claims establish substantive rights that a state actor may violate, it does not contain a remedy against that state actor for such violation. And there's a reference, 2023 reference. Therefore, this claim must be dismissed. G. Wallace's state law claims must be dismissed. Wallace's assault and battery claims must be dismissed for failure to state a claim upon which relief can be granted, sixth and seventh cause of action. Wallace's state law assault and battery claim is the same as his 42 U.S.C. Section 1983 excessive force claim. He alleges excessive force was used by pointing the gun at him and then taking him into custody. First, any touching of Wallace was privileged as it was pursuant to a valid arrest, and he does not allege any facts suggesting unnecessary force was used to force him or handcuff him. Second, the assault claim involving the pointing of the gun fails for the same reasons. Wallace's Fourth Amendment excessive force claim fails. Another reference. The standard for common law assault and battery by a police officer mirrors the federal civil rights law's standard. 2. Wallace's false arrest and false imprisonment must be dismissed for failure to state a claim upon which relief can be granted. Eighth course of action. The false arrest imprisonment claim is identical to Wallace's Fourth Amendment unreasonable search and seizure claim. The probable cause analysis is the same whether under federal law or state law, Nevada state law. Reference, probable cause only requires slight evidence. In addition, the officers are protected by discretionary immunity under Nevada Revised Statute 41.032, another reference, holding that an officer's decision to arrest based on a matched description in a facially valid warrant was entitled to discretionary immunity. In Gonzalez v. LVMPD, the Nevada Supreme Court evaluated the application of the discretionary immunity doctrine in evaluating the officer's decision to arrest and detain a suspect. In Gonzalez, the court found LVMPD's decision to arrest or detain Gonzalez based on a warrant was part of a policy consideration that required analysis of multiple social, economic, efficiency and planning concerns, including public safety. Another reference. Concluding that no civil liability attached to a state trooper's decision to arrest a driver for allegedly refusing to sign a traffic ticket because the decision to do so was a discretionary decision requiring personal deliberation and judgment and thus entitled to immunity under Nevada Rules Revised Statute 41.032 brackets 2. Another reference, the decision of whether to make an arrest is largely discretionary. 3. Wallace's invasion of privacy claim must be dismissed for failure to state a claim upon which relief can be granted. Ninth course of action. Nevada's common law recognises the tort of invasion of privacy for unreasonable intrusion upon the seclusion of another. The purpose of the tort is to provide redress for intrusion into a person's reasonable expectation privacy. Another reference. The tort of invasion of privacy embraces 4 different tort actions. A. Unreasonable intrusion upon the seclusion of another, or B. Appropriation of the other's name or likeness, or C. Unreasonable publicity given to the other's private life, or D. Publicity that unreasonably places the other in false light before the public. There's references. Wallace alleges the offence officers committed this tort by searching him. However, as set forth above, the search was lawful as it was a basic search pursuant to a lawful arrest. 4. Wallace's negligence claim must be dismissed for failure to state a claim upon which relief can be granted. 10th cause of action. Wallace alleges the officers conducted a negligent investigation that led to his arrest. Therefore, if the arrest was lawful, this claim fails. In addition, the officers are immune pursuant to Nevada Revised Statute 41.032. Another reference. The nature of an investigation is inherently discretionary. Conclusion. Based upon the foregoing, the defendant officers request they be dismissed from this lawsuit, dated this 1st day of September 2023. So there we are at the end. All there will be is, there's the exhibit, which was a compact disc. I hope you enjoyed that. My apologies for the break in my audio. I did notice it eventually when I was looking at my meters and saw that you weren't hearing anything. Hopefully it didn't stop your enjoyment too much. If you're watching the screen, you've got to read that bit twice, like me. A case of deja vu. Thanks for coming in. It's obviously quicker if I do it this way. I can get it out quicker this way than doing a pre-record. You get my mistakes if I do it this way, but hopefully you enjoyed it. Got it out quickly. It's only just come out, so. And thanks to it was an individual actually who drew my attention to it. I am registered to the docket anyway, so I do get updates on this docket. So if I'm about when an update comes out, I will try and do the reading. Thanks for watching. We don't have, or to my knowledge, we don't have any arrests for today. I know that Afro Audits, is that his current name? Can't think if that's his current name. Yeah, that's his current name. Afro Audits has a bench trial today, and his mate Buttcrack, whatever he's called, News or something like that, went in to give evidence on his behalf. I bet that went well. What else? Lafayette County Audits. The guy who was done for the DUI in Galveston, he has waived his right to extradition, and a capious bond has been set at $100,000. So that's another one. There's a small update on Benghazi Rabbit, because the individual under the mask, or the individual behind the camera, has changed. And the current individual has just received notice of a charge that he's got to attend court on September the 11th, and it's for publishing the name and photograph of a public official, and it's a class 1 misdemeanor. So that's really everything else that's gone on today. Thanks for coming in. I won't go through anyone in chat because I'm grateful to all of you for coming in. I want to keep it, condensed really down to the reading of the motion, but I am really appreciative of you coming in. Thanks for watching. I'm going to say goodbye now. Good night. Oh, I know later today, Artie's Corporate Fiction is having a 15,000 subscriber celebration stream. If I'm awake at the time, I may go on and congratulate him. If I miss it, congratulations on getting to 15,000. It's an achievement. I don't really know too much about the start of your channel, Corporate Fiction, and Artie, whether you just sort of did it as a hobby like me, and it's grown organically without, really any plans for doing anything with the channel. I mean, that's how I started. Just started making videos and people started watching them. So, and to me, it's still very much a hobby. But congratulations to Artie's Corporate Fiction for reaching that milestone. Thanks for watching. Good afternoon to those of you over there. Good evening, good night to those of you over here.